What's going on, everybody? It's your Uncle EJ, always your mother's brother and your grandmother's good looking son and your grandmother's good looking son. I got my glasses and all that. You know what I'm saying? Smoke them if you got them. We got to talk, bro. So, although saying Norbes was never a partner, although saying Norbes was never a partner, you may be correct. Although saying Norbes won't get nothing, you may be incorrect. But we got to talk about it. You know, a couple of people have already broke the news. I was on my trip to New York on a plane, that was nonstop, but somehow got diverted to 3 other damn cities because of a thunderstorm. But that's neither here nor there. We're going to break it down. I got all the paperwork, but we're just going to talk in general. If y'all want me to read it, we'll talk about that too. But Lego.
Representing that wave gang, EJ, always. EJ, always. EJ, you are now rocking with DJ Ladybug. On the ones and twos, and just call me Monty on everything.
So as we know, if you're a member on the channel, I said that there was originally a conference that was scheduled between the two parties and the judge over the case and the motion to dismiss as put forth by URL and their attorneys. Also said that it got moved to the 23rd of March at, I believe it was 10:30 or 11:30 a.m. I forget right now. But basically they had this meeting. I was checking the website, to see if it was going to continue to update, because I knew something was going to be dropping as far as information or an order by the judge on the ruling of the motion. So as it turns out, before in an earlier blog, I spoke about that the judge and the court recommended that this case go to mediation. And why was that? Obviously, from the merits of what the judge thought was a case, both sides have an argument. One, the URL has an argument that basically the judge said that Norbes never incurred any losses in his partnership with the URL. And a partnership is not the same thing as ownership. And since he didn't incur any losses, then basically he doesn't have a claim for ownership. So anything related to ownership basically got thrown out by the judge. But the judge said some things in his order that I found interesting. One, did URL actually get paid $113 million by Caffeine? Because what bloggers talk about and what, kind of the media reported was that Caffeine raised $113 million. But did URL actually get this money for 10 years worth of licensing and whatnot for URL's product? I guess we'll find that out unless the case gets settled. So to talk about specifically why it got thrown out, the judge basically granted part of the motion and suppressed other parts of it. Oh, EJ, I got the paperwork. Let's see. Let's see. So the complainant fails to establish the existence of a partnership. The formation of a partnership requires a shared purpose and knowing mutual asset by all parties to a partnership. A partnership is an association of two or more persons to carry on as co-owners a business for profit. Partnership law, section 10. No person can become a member of a partnership without the consent of all partners. Partnership law, section 40. Paragraph 7, where there is no written partnership agreement between the parties, the court must determine whether a partnership in fact existed from the conduct, intention, and relationship between the parties. Let me see. And I just want to skip to the meat and potatoes because it's not necessary for me to read the entire thing. Let's see. Okay, here we go. Plaintiff has construing the plaintiff in the life most favorable to plaintiff on a motion to dismiss. The court can infer that the plaintiff has alleged the intent of the parties to form a partnership from plaintiff's allegation that plaintiff was approached by the defendants to be a partner and to form what would now be the Ultimate Rap League. However, plaintiff pleads no other facts in support of the parties' intent, and plaintiff has not alleged that have not alleged all of the elements required to establish the partnership, which is what I stated beforehand, which he basically has to prove that he incurred losses as well. Plaintiff also sufficiently alleged joint management of the business at the pleading stage. Plaintiff alleges that from 2009 to 2020, plaintiff as a partner executed many activities that included but were not limited to the following: recruiting talent, engaging in promotion, hosting rap battle events, organizing battle rap events, executing contracts, raising capital, and developing business concepts for the Ultimate Rap League. Complaint 17, and that from 2009 to the present, the Ultimate Rap League has featured the talent that plaintiff has secured to perform for the company at its live events and on its digital platform. Complaint 18. Defendants argue that the plaintiff does not allege to have been involved in quote unquote business decisions, including financial decisions, and did not have access to or control of the streaming part of the business. Based on the record before the court, URL has three aspects to his business: recruiting talent, hosting live events featuring that talent, and streaming or otherwise selling footage from the live events. Y'all remember that. Y'all remember that, because that's basically what URL produces. And it's up to Norbes to prove that the part one, recruiting talent, he's done that, as we all well know. Hosting live events featuring that talent, he's done that as well. And the streaming or otherwise selling footage from live events. According to the complaint, plaintiff was involved in two out of those three aspects of the business: recruiting talent and hosting live events. Accordingly, plaintiff has alleged sufficient control over the management of the business to survive a motion to dismiss. Nevertheless, plaintiff's partnership's claims fail because plaintiff fails to allege that he was responsible for the losses of URL, which was clearly a startup business in 2009. The complainant alleges that the plaintiff would quote unquote share profits when made available from some of the URL events, more specifically, quote unquote, Born Legacy and Proving Ground events, and received alleged profits in cash. Complaint 258. The complaint also alleges that the plaintiff and defendant shared losses on an equal basis, but alleges no facts or specific instances that would support this allegation. As stated above, conclusory allegations need not to be taken as true. The only expenses which are distinct from losses, and the reason why expenses are distinct from losses, because expenses you get reimbursed for. Losses, you never get them back. And so the court is saying that since Norbes never suffered any losses of the URL, basically being a startup business from 2009, that he can't be what you would call an owner, but he can be a partner in a business venture, as we're going to read further. The complainant also alleges that the plaintiff and defendant shared losses on an equal basis, but alleges no facts or specific instances that would support this allegation. As stated above, conclusory allegations need not to be taken as true. The only expenses which are distinct from losses referenced in the complaint were reimbursed. Additionally, the complaint does not allege that the plaintiff ever contributed capital to URL. All parties acknowledge that, quote unquote, the requirement that parties have agreed to share in the profits and losses is an indispensable element of a contract or partnership, contracted partnership or joint venture. Accordingly, plaintiff has failed to state any cause of action based on an alleged oral partnership, and following the causes of action must be dismissed. So here are the causes of action that were dismissed by the judge in the motion, or basically granted. Wrongful dissolution, which has to do with a partnership; breach of oral joint venture or partnership agreement; breach of the implied covenant of good faith and fair dealing; equitable accounting; conversion, declaratory relief; determine the existence of a partnership; declaratory relief; dissolution by decree of court; and declaratory relief, plaintiff rights to partnership recovery. So when certain people told you that basically everything that has to do with ownership was basically granted by the court, that was correct. However, the way you say the word fiduciary is not correct. But that's neither here nor there. I'm a quick capper. But here's what the court did see, though. The court did agree that for 10 years, Norbes has worked for URL and that there's no contract between them. Not a 1099, not a contract of services, not anything. But URL did still receive services from Norbes and did not pay him for certain services. They also agreed that based on the complaint that that the URL used Norbes likeness. So let's go further into the things that they did grant. Um, Plaintiff's breach of fiduciary duty and quasi-contract claims are sufficiently stated. 4, breach of fiduciary duty. 7, promissory estoppel. 8, unjust enrichment. And 9, quantum meruit. So since we have the advent of wonderful things like Google, we could just ask it what the hell some of these things mean. We don't have to guess, or we don't have to have folks break them down for us. So when we talk about fiduciary duty, if anybody knows about real estate, your real estate agent has a fiduciary duty to deal with you in a way that's beneficial to you first, not to them first. If not, they can be sued. So your real estate agent has to be out for your best interest at all times. So the court is saying that since Norbes trusted Beasley like a friend and thought that Beasley had to have Norbes' best interest at heart whenever he was doing these things, especially when it comes to finances. But let's ask Google. Hey, Google, what is breach of fiduciary duty when it comes to law?
On the website varganzalalaw.com, they say, a fiduciary duty exists when one party has an obligation to act in the best interest of another party. When the fiduciary acts in their own best interests instead of that of the other party, it results in a breach of fiduciary duty.
Okay, Google, what is promissory estoppel?
Here's a summary from Wikipedia. Estoppel is a judicial device in common law legal systems whereby a court may prevent or stop a person from making assertions or from going back on his or her word. The person being sanctioned is stopped. Estoppel may prevent someone from bringing a particular claim.
So basically, Beasley would promise the same being made to him. The court is saying that he's owed some things, or excuse me, that they deserve to keep going forward to see if he's actually owed anything. But Norbes has a case. Number 8 is unjust enrichment. And it sounds just like it sounds that the URL unjustly enriched themselves off of Norbes's talent and talent acquisition, hosting live events, and his likeness. We know URL is much bigger than Norbes, but I'm just saying what it means that URL used Norbes' talent acquisition, which they said is 1/3 of what they do. Him hosting live events, which is 2/3 of what they do. And they use that in order to get a $113 million caffeine deal. Now, what's in question is if URL actually got paid $113 million by caffeine, because in the court record, it actually infers that they may have been paid themselves, which is why Norbes, when you think about being 1 to 2/3 of what they do, would even bring up a claim, or excuse me, would have basis for a claim. So with that being said, the case is going to be moving forward. I don't feel like reading all that stuff because it's a lot easier when I just tell you what's going on. But, you know, I get the information almost. I get it. All I got to do is refresh a page or two. But regardless, the case is going to be moving forward. And the judge agrees that looking at some of the stuff that we need to kind of look at this because it looks like somebody might have got effed over. And that somebody would be Norbes. That Norbes worked for the URL for 10 years, expensed stuff, and was expected to be paid because certain promises were made to him, and those promises weren't fulfilled. So they have to go to court in order to decide that. But do they actually want to go to court and risk all of the paperwork, all of the books coming out, all of the, you know what I'm saying, how URL operates coming out into the public eye, or, you know, in Uncle Sam's eyes? And I don't think so. But based on this, the case is going forward. And I think that, as I've said a long time, that URL is going to have to settle, or are going to want to settle, because the thing is that they're going to end up owing him. I mean, just by reading, I said 2/3 of what he was doing is 2/3 of what they do. And he's been doing that for 10 years. And they never said, no, don't do it for us. They always was like, yeah, we got you. We're going to break bread with you. We're going to do. These are Norbes' words that they're going to eventually take care of him. So all these things are alleged. But I know a couple of people that watch the channel are really interested in this, almost like, you know what I'm saying, watching you know, court TV or something like that because it's so close to battle rap. But like I said in other blogs, when it came to this, battle rap is big business now. The judge is saying somebody got enriched, unjustly enriched, allegedly. And we got to talk about that. We got to put everything out and see. So as we know, in some things, when things are supposed to come to light, they don't come to light because people settle. They sign non-disclosure agreements. So I would imagine that the next thing that we hear, if we don't start hearing things about discovery, which I will know immediately once it happens. So make sure you subscribe to the channel. Things like discovery and whatnot, and interrogatories of different witnesses, you'll start finding out things that I don't think people really want you to know. I don't really think URL wants you to know how they do business or how they've done their business. And so that's why certain things will be redacted, but even still, certain things will come to light. And it looks like the more and more that we find out about things that, the URL is kind of out for themselves. And so as battle rappers, man, y'all need to handle y'all's business. You know what I mean? I remember watching the DME blog where he was talking about Your Honor and being in a contract with the URL where he doesn't get paid and he's not necessarily promised anything. He just can't battle on any leagues that are in direct competition with URL. That's a limit. Even as an artist, artists are known for, the first contract not getting anything of what they want, basically just being, almost a prostitute to the contract. But as a battle rapper, when you got a contract with somebody that doesn't have anything to offer you, that's not beneficial to you. You know what I mean? Even if you think it's about notoriety, it's not beneficial if you have no promises, because there are certain battle rappers out here who went the other way around, who made their names notable through hard work and going on other leagues. Y'all guys can do it too. You can do it too. Oh, you haven't been up to depth on this theory? Ongoing thing, sir. It's too much to talk. But so moving forward, y'all stay in tune with the channel. I'm gonna be dropping more info. I've also got an interview with Gwitty coming up. It's going to be a one-on-one. That's going to be a real in-depth interview about I would say it would be about his dealings in battle rap and with certain individuals within the URL and certain battle rappers, but basically telling his truth. And I don't want to call it a untruth or nothing like that, because that's Chris's thing. But basically, he hollered at me and told me he wanted to talk to me about that, because I chop it up with him all the time. And so we're most definitely going to do that. We're also going to be interviewing Miss Frank Nitty after her battle with Smoking NY, and the whole squad going to be pulling up. We're going to have to talk about, us going to the Best of Mike event and pulling up in New York and all that, which I had a grand old time. And if y'all in New York, man, Rocky's Deli, son. Oh, Rocky's Deli's fire. Rocky's Deli's fire. I had the chopped cheese. Yeah. Well, I don't know if they could lose the caffeine deal over this, K-Felon, but I think they're going to lose some of the bread from that caffeine deal. They're going to have to break bread. That I do think, because I've got court records where the attorneys for Norbes have subpoenaed information from Caffeine, and Caffeine hasn't provided it yet. But basically, once we go to court, the judge and the court have ways of getting that information to them. So once that information is known, what's known actually, what is actually getting paid to the URL and how much they profited off the URL, because that's going to be one thing that's major in order to prove the unjust enrichment. We're going to have to understand just how much money you guys made off of him. And it's not only the caffeine deal, it's also all the money that you guys made off of live events that he promoted, that he used his likeness, the Born Legacies, the PGs, all of that comes into question. All of that comes into question. So make sure y'all stay in tune with the channel, and I'll be updating y'all. Later on today, I'll probably be coming on with Wave Game Radio. So y'all stay tuned for a for an update or a message about that on your social media platforms. But like I said, Monty.
EJ, always. We rock with you long ways all day. Representing that wave gang. And y'all all know what's that wave thing. Logged up to the block down. Got the intro for the fans now. So subscribe now. Hit the like too for the 1-9 like I'm Juju. Your mother's brother. And your grandmother's good looking.